Y'all, TIandTiny won $71 million in a trademark infringement lawsuit. As reported here by BET.com, this is the third time that TIandTiny have gone to trial on their trademark litigation against LOL Surprise Dolls. I did a couple of reels on this a year or two ago where this litigation was going forward. In the first case, it was a mistrial because inadmissible evidence came in. In this second trial, TIandTiny actually lost, but a case out of the Supreme Court determined that their loss should be overturned. And now a jury has come back and they have agreed that LOL Surprise Dolls infringed on the likeness and the image of the OMG Girls, the group that was officially run by TIandTiny and included one of their children. Business owners, there's so many trademark tidbits we can learn from this case. So $17.8 million was actual damages. In most cases, actual damages is the amount of money that the plaintiffs lost as a result of the infringing activity. Because TIandTiny weren't selling dolls of their own, this number was likely produced by the amount of profits that were made off of the dolls that were considered infringing. In the litigation, TIandTiny said there were about 32 different dolls that infringed on the OMG Girls, and the jury came back and said not all 32, but about 12 of them were actually infringing on the images of the singers in the group. Now, the other $53 million came from punitive damages. In trademark law, if someone intentionally infringes on a mark belonging to another person, they could be liable up to the triple amount of the damages owed. While I don't know the actual exact calculations, it looks like this jury tripled the $17 million in actual damages to come up with the approximately $50 million in punitive damages. From the beginning of this case, the owners of LOL Surprise Dolls tried to play stupid. It's my understanding that the parties tried to settle out of court and try to resolve the case, which is normal for a trademark litigation matter. But all the way up and through trial, the LOL Surprise Doll Company says, "What? We don't know what you're talking about. These dolls look nothing like the actual singers. Look at this clip from Billboard.com, and you decide, was there infringement?" Another important lesson out of this case is the difference between potential confusion and actual confusion. Actual confusion is facts, evidence, times in history where they could show the plaintiffs that someone confused the origin or the source of these goods. So if they were able to show that people thought LOL Surprise Dolls were from or belonged to the OMG Girls and they somehow profited from them, or people were buying these LOL Surprise Dolls because they thought they were supporting the OMG Girls, that would be a source of actual confusion. Likelihood of confusion can also be shown through surveys and polls that the plaintiffs take to see if people who are customers or likely customers would believe that these products were sold by the OMG Girls. And if the plaintiffs are able to prove likelihood of confusion, they can win in a trademark case just like they did here. Congrats to TIandTiny. So even though the OMG Girls, they were a big group for a time, but it kind of fizzled out, their investment into the trademarks, the branding, the identification of the OMG Girls, the uniqueness of their look, paid off to the tune of $71 million. If you don't currently follow me, I'm attorney LBJ. I am an intellectual property lawyer who likes to help small businesses understand trademark protection through topics like TIandTiny. I want to know from you, do you think that this result was fair? Is $71 million too much? Is it not enough? Would you be confused with the source of these goods? Don't forget to give me a follow.